The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. Thank you for spending an hour of your time to go through Bill 132 and sexual violence and harassment in the workplace. My name is Adam Curtis. I'm the Senior Director of Corporate Investigations with AFIMAC Global. We're currently in our Milton office in a lovely sunny but windy day in Toronto. I'd like to introduce Natasha Savoline from Bernardi Human Resources. Natasha.
Good afternoon, everybody. Thanks for joining us.
So Natasha will start off, I think, Natasha, with Bill 132. What's come into force?
So we saw some changes to the Occupational Health and Safety Act with Bill 132 that took effect on September 8th, 2016. The name of the act that brought in the changes is the Sexual Violence and Harassment Action Plan Act, Supporting Survivors in Challenging Sexual Violence and Harassment 2016. So what we're seeing are some amendments to the Occupational Health and Safety Act, which I'll call OSHA for short, and it deals with 4 specific areas. If people heard anything last year, in the last couple of years, with the provincial government's campaign about how it's never okay in an action plan to stop sexual violence and harassment, this is one of the things that came out of that. So the amendments address 4 different areas in the Act: sexual violence, sexual harassment, domestic violence, and matters related to that. One of the first changes that we'll talk about is a change to the definition of workplace harassment. So workplace harassment has been in the Act since June of 2011, when we saw changes with Bill 168, which a lot of people may have heard about. So these new changes, one of the big things that it does is that it expands the definition of workplace harassment to include a definition of workplace sexual harassment. The definition includes 2 separate things. The first is engaging in a course of vexatious comment or conduct against a worker in a workplace because of sex, sexual orientation, gender identity, or gender expression, where the course of comment or conduct is known or reasonably to be known to be unwelcome. So there's no definition in OSHA of those 4 grounds: sex, sexual orientation, gender identity, or gender expression. So the expectation is that it will likely be defined similarly to the way that it's defined under the Ontario Human Rights Code, because all 4 of those things are grounds under the Ontario Human Rights Code. So when we're talking about the ground of sex, that refers to what somebody is biologically. So biologically, is the person male, female, or somewhere else along the spectrum, which is possible as well. Sexual orientation includes everything under the transgender umbrella. Gender identity is each person's internal and individual experience of gender. So it's their sense of being a man, a woman, or somewhere in between on that spectrum. It's not intended to protect people who are biologically female and very feminine and identify as female, or somebody that's biologically male and identifies male as a man. It's meant to protect the opposite. So somebody biologically male who identifies female and vice versa. Gender expression is the way the person outwardly displays their gender identity. So things like how they dress, how they do their hair, their makeup, what they prefer to be called, body language, how they talk, all of those kinds of things would be included in that. So the definition also refers to workplace, And one thing to point out is that workplace goes beyond the four corners of the workplace. So it's not just where people report to work, but everywhere they may travel to do their work. And in some cases, it can go beyond that to include even social situations or social media where there's harassment going on that's affecting a worker's workplace. The second thing that is included in the definition of workplace sexual harassment with the changes is making a sexual solicitation or advance where the person making the solicitation or advance is in a position to confer, grant, or deny a benefit or advancement to the worker, and the person knows or ought reasonably to know that the solicitation or advance is unwelcome. So again, it doesn't define who would be captured by that definition. However, we know supervisors or managers would obviously be captured by that. So basically any senior leader or officer or director in your organization. But you can imagine times when it could also capture people like lead hands or team leads. And in some cases, you might even have a situation where the union exec could be captured in that as well. One very welcome addition to the Act for employers is that it has a provision that talks about what is not harassment. So what it says is that a reasonable action taken by an employer or supervisor relating to the management and direction of workers or the workplace is not workplace harassment. So anything that would fall within that would not be included as workplace harassment under OSHA. Some of the things that we might see in that regard in terms of what will not be workplace harassment are things like performance management that's legitimate, where somebody actually has performance problems, putting people on a performance improvement plan, for example, requesting medical information when somebody is away from work or on a sick leave or long-term disability leave, discipline that's warranted, the enforcement of workplace rules and policies. As long as these things are being enforced consistently, we're having the same standards applied to all workers, and we're not going to see a problem with it. Things like changes to work, schedules, assignments, that kind of thing. And then normal interpersonal conflict or disagreements between people. So we're not going to get along with everybody. There's going to be situations where people disagree, even have heated disagreements. That will not constitute workplace harassment, provided it doesn't get to a point where it's hostile or abusive.
So duty to investigate, there's been some key changes with Bill 132 as well as known. There's been a duty not to turn a blind eye and sweep things under the carpet, and it's now incumbent upon the employer to investigate properly, ensure that proper protocols and policies are followed in regards to the new legislation. In simple terms, if a manager becomes aware of an incident, they're obliged to report the matter and investigate it. Even if the employee just purely discusses the matter, it's their duty to ensure that it's properly and ensure that it's investigated in an appropriate fashion. So this is, I think, a great part of the legislation in that it ensures that the investigation into incidents and complaints of workplace management are appropriate in the circumstances, and they're investigated in a fashion that is objective and in some cases independent. When we're faced often with incidents and complaints, the employer will be required to ensure that appropriate investigation is conducted. It can be at the employer's discretion to ensure that it's either formal or informal, and this purely depends on some of the circumstances surrounding the incident, which may determine the level. Some instances may that the employer needs to act quickly to ensure that there's best evidence and to show that the matter's being taken quite seriously. The employer needs to ensure that people are trained specifically in the law surrounding the harassment or the bullying in the workplace, and that they can conduct the investigations. You need to ensure the investigator is knowledgeable in the law and the policies, that they're unbiased, and that they facilitate some form of resolution. Must also ensure that they have sufficient authority to conduct the investigation and that there's no conflict of interest. More importantly, an employee does not have to make a written complaint, a formal or verbal complaint. If an employer, supervisor or any member of management becomes aware of the matter or reasonably be aware of any incident or complaint, they have a duty to conduct an investigation in an appropriate manner in the circumstances.
So one of the other changes that we've seen with these new amendments to the Act, one of the key changes is that the Ministry of Labour now has some authority to come in and do something about it if an employer does not conduct an appropriate investigation, doesn't handle things properly. In the past, although we had the workplace harassment provisions that were brought in June 2011 previously, the Ministry didn't have any authority to come in if a worker felt like the employer wasn't following its policy or wasn't doing a proper investigation, or they didn't agree with the outcome, perhaps, of the investigation. So one of the key changes is that the Ministry will now be able to come in and order an employer to hire an impartial person to investigate and write a report at the employer's expense. So that's a big, big change. This means we don't know actually what it means in terms of when they're going to come in. We're going to have to see how that sort of is shaped by the complaints and the law that follow the changes. However, what it does mean is that there is that risk, and that it is important, as Adam said, to make sure that your investigators are properly trained, your managers and supervisors are properly trained, so that we can avoid that type of outcome. So the presumption is that this wouldn't be ordered where the employer was not given a reasonable opportunity to first address the situation. But like I said, we're going to have to see how any challenges play out with the Ministry.
I think the key point as well, Natasha, there is impartial. And impartial may just be a member of your own internal corporate security, or it may be a manager or a supervisor or someone from another department in the human resources area. And again, that could depend on the seriousness of the allegations and how you determine which person would conduct that particular investigation.
So one of the other things that comes in with the changes, there's two things. There's a requirement to make some changes to your policy, and there's also a requirement to make some changes to your program, which are two separate things, but a lot of employers put them into one document, and it's fine to do so. But we'll deal with them separately because they're dealt with separately in the legislation. So one of the things is in terms of the policy, what has to be done. And one of the things that was introduced as well as a result of the changes, and it was really shortly before the changes took effect, was a code of practice. So the Ministry of Labour in August released its code of practice, which sets out a number of guidelines that are available on the Ministry's website to employers to determine how they can go about meeting these new changes, these workplace harassment provisions of the Act. So that's well worth a read if you haven't taken a look at that lately. But one of the things that it does set out is that your policy has to include 7 elements at a minimum. So the first is that it has to include a statement or statements demonstrating the employer's commitment to addressing workplace harassment. That code of practice does include a template policy that does include a statement that you could use and insert in your own policy if you'd like to do that. The second thing it needs to include is the definitions of workplace harassment, including workplace sexual harassment, and to set out what is not workplace harassment. All of those things are right in the Act and can be pulled directly from the Act. The third thing it needs to include is a statement indicating the policy applies to all workers and that it addresses workplace harassment from all sources, such as customers, clients, employers, supervisors, workers, and members of the public. There may be other people that you want to include in that group depending on your particular organization. And the other thing I'll mention is that workers is defined very broadly in the Act, and it does include people that aren't necessarily full-time permanent workers for your organization. So you should take a look at that as well to make sure that everybody knows that it encompasses all of these people. The fourth thing it should include is a statement encouraging workers to report workplace harassment to the appropriate person. And the appropriate person is something that does have to be defined in your program in terms of particular positions or designated individuals. The fifth thing that it needs to include is a statement that the employer will investigate and deal with all complaints or incidents of workplace harassment in a fair and timely manner. And the policy must specify that information about a complaint or incident will not be disclosed except to the extent necessary to protect workers, to investigate the complaint or incident, to take corrective action, or as otherwise required by law. So best practice would be to actually include that statement right in your policy and program. The sixth thing it needs to include is a statement that a worker is not to be penalized for reporting an incident or participating in a workplace harassment investigation. We call that a reprisal under the law and under the Act. Penalizing a worker for exercising their rights under the OSHA is prohibited and against the law. The last thing that needs to be included in the policy is information about other resources available to a worker to seek help in that particular situation if they have experienced workplace harassment. So that could be, for example, the union, a joint health and safety member or rep, human rights legal support center, or employee assistance programs, for example. The policy can be combined with other policies that you have. So if you have a violence policy, you can combine the harassment policy with the violence policy. Or if you have another policy that deals with discrimination and harassment under the Human Rights Code, for example, you can combine this policy with that policy as well. It has to be posted somewhere where employees are easily going to see the policy. They're posted in the workplace. And it has to be dated and signed by the highest level of management, whether that be a CEO, CAO, president, whatever it is, that person needs to sign the policy. So as I mentioned, you also have to develop a written program, and that has to be developed to help to implement the workplace harassment policy. This is not new, so we had this in the Act for years regarding workplace harassment and workplace violence, so it's not a new thing. It just means that you've got to amend your program to deal with the new changes that have taken effect. So the program should set out the steps that will be taken to implement the policy, and the code of practice that I mentioned sets out the specifics of that, but in general, it's going to cover things like training for your workers and supervisors and managers, designated individuals to report to. Here's an incident or complaint. Designated individuals who may be the ones to conduct the investigation. And it's essentially the how-tos in terms of how the provisions of the policy will be applied in practice, and what steps the organization has taken to address the changes and implement the policy.
In regards to developing these policies in conjunction with health and safety committees, it's new that in consultation with them, you need to do that. And it's important. I'll give you an example. If you have a workplace violence or harassment investigation, you need to involve the Health and Safety Committee, and they need to be updated on the processes or the progress of your investigation and any possible changes that you may recommend that would increase the safety of the employees within the workplace that you've identified in that investigation. We'll touch on some key points later on in the PowerPoint in regards to those. Also, with the new requirements, you need to outline the investigation procedure and processes, such as how will it be conducted, how incidents and complaints of workplace harassment will be investigated and dealt with. This is not new, it's just been reworded. However, the new measures are the procedures for workers to report incidents of workplace harassment to a person other than the employer or supervisor if the employer or supervisor is the alleged harasser. On the following slides, we'll address these points in more detail. So outlining the investigation procedure. To whom will the person complain? And we've got to ensure confidentiality. Who will investigate it? Will it be HR, supervisors, managers, corporate security individuals, or just a designated third-party provider? Recommend that the policy speaks to discretion. So again, is the investigator going to be internal or external? We also must consider the witnesses. Are they relevant? Reasonable efforts to interview all necessary employees or non-employees, as well as the respondent. And that may include providing notes, as well as including interviews with witnesses and or statements. Also importantly is the time parameters. So the timing, and it states in best efforts to complete within 90 days, but it can take longer, and again it depends on the circumstances of the investigation. Well, there may be extenuating circumstances, and this is interesting. They've stipulated more than maybe 5 witnesses, which may extend the investigation, or the unavailability of witnesses due to illness. An interesting matter would also be if it's actually been reported to police and an actual criminal investigation is now ongoing. So that may delay your current investigation. It doesn't have to be overly detailed or lengthy. And some employers like to indicate that the policy that the report will not be provided to parties involved in the investigation. So it may also stipulate just some recommendations.
So Adam mentioned that one of the things that has to be included in the program is a provision or a statement indicating that employees or workers will have the ability to report to someone other than the employer or supervisor if it is the employer or supervisor who is the one that they're alleging has harassed them. So you can imagine, depending on each organization, that's going to be different. If it's a large organization with someone in a human resources role or a human resources department, then that's one option. We generally would like to include as many different options as possible. So human resources, any member of management. We always like to say there's no chain of command when it comes to harassment and bullying and things like that in the workplace. So they should be able to go to any member of management in the organization, any senior leader. But you also need to include some designated individuals. So whether that be people by name or just named by position, in case people obviously come and go in positions. So naming people by position is another option. And in certain smaller organizations, you may actually need to have somebody almost on retainer as a consultant where employees can go, right? There's no option internally if we're dealing with a small business with an owner. Where else can people go? They may have to go external to report that. So that's one possibility as well. Adam also mentioned the need for confidentiality. So that's something that's been really emphasized throughout the changes, and it's emphasized quite a bit in the code of practice. So what it says, and this is a new provision, this is something new in the Act, it says that information obtained about an incident or complaint of workplace harassment, including identifying information about any individuals involved, will not be disclosed unless the disclosure is necessary for the investigation or for corrective action or is required by law. So as I said, I do recommend including these types of statements in your policy so that it is made clear to everybody what the expectations are around confidentiality, and they have some assurance of the confidentiality of the information that will be used in the investigation. More on confidentiality. To protect the privacy and confidentiality, and out of respect for the individuals involved in the investigation, as well as to protect the integrity of the investigation, it is essential that the complainant, respondent, witnesses, and anyone else involved in the investigation of an incident or complaint maintain confidentiality throughout the investigation and afterwards. So that's a statement you actually can include in your policy, something to that effect. But you do want to make people aware, and you want to tell them at the beginning of the process, and this is another thing that is suggested and recommended in the Code of Practice, that you do make those expectations about confidentiality clear to people from the get-go when they're initially involved in the investigation. So you want to make known to them that the complaint and investigation is strictly confidential. You want to make sure you're keeping a separate investigation file. We don't want the investigation file mixed in with the other personnel files of these individuals. Like I said, setting that expectation of confidentiality. And that should be set not only with the people involved, but if any manager or supervisor or department, for example, is aware that there's an investigation going on in their department, even if they're not a witness, you need to be clear with them about the expectations that their obligations in terms of keeping it confidential amongst their employees and watching for any kind of chit-chat going on in their departments to make sure they're putting a stop to that so that it's not happening through the investigation. And another thing is to make sure that you are meeting with people individually, separately. So we're not doing joint interviews of witnesses, for example. I've heard some stories about that. So that's a definite no-no. You want to interview everybody confidential, separate interviews. You want to make sure you're not telling witnesses who the complainant is and who the respondent is. You're obviously going to bring up those names and ask some questions, but we don't typically come right out and disclose that. Complainants and respondents generally don't know who you've interviewed as witnesses, although they will suggest some people typically through the process. One of the other big changes that came in with the Act is that there is now an obligation to inform the parties in writing of the outcome of the investigation. So you've got to let them know the results of the investigation and any corrective action that has been taken or is going to be taken. So when we talk about that, You don't have to provide a copy of the whole report, and we typically suggest you do not provide a copy of the whole report because all it does is open up the debate about whether or not the findings are correct. So typically what's provided is just a very bottom line written summary of the finding. You let people know we received your complaint, we did a thorough investigation, and we either did or did not find that harassment was substantiated based on your allegations. You do that separately with the complainant and the respondent. And typically, I would say, because of the facts, as I'm going to talk about in a moment, that you do have to advise people now about the corrective action. I think it's important to let the respondent probably know first about corrective action rather than letting the complainant know ahead of time. So one of the big changes, one of probably the most controversial change that came into effect, is that we now have to let people know about any corrective action that's been imposed on somebody if we find harassment. So we've got to let them know, and we're going to have to see how this plays out again. I think for now people are trying to take as cautious an approach as they can to try and maintain that privacy and confidentiality as much as possible. So for now people are trying to be as general as possible, indicate there was a suspension, a transfer, dismissal, without going into specific details if you can. However, that may be something that changes as the case law shapes that particular provision, and we'll have to see what happens. But just as a practical point, that confidentiality is very important in this regard, and so I think you need to have, if you have a situation where you have disciplined somebody, you've got to let a complainant know about that. You're going to want to have them sign confidentiality agreement of some sort, indicating that they will not then communicate that elsewhere, other than, for example, if they need to talk to the union or a legal advisor, so on and so forth. And with both the outcome of the investigation as well as the corrective action, that needs to be communicated to the complainant at least within 10 days of the conclusion of the investigation. One of the other changes is around training requirements. There's always been training requirements. So this particular requirement in terms of all workers is not new. But what is required is that you have to provide your workers with information and instruction that is appropriate for that worker, those workers, on the contents of both the policy and the program. So you've got to give them instruction on harassment and sexual harassment, and it has to be provided in a manner and language that those employees understand. One thing that is new is the specific training of supervisors or managers. They need to be trained specifically on how to recognize harassment and how to handle an incident or complaint if it comes their way. And that's important for you to make sure you're meeting your legal obligations and nothing's sort of, being swept under the rug or isn't being, they're not paying attention to something and then you have a complaint down the road. So they need to be trained specifically on that. And it also requires that you keep the information about that training for at least a year after the training has been provided. Some other new things, more training for Joint Health and Safety Committee or reps. So you've got to train them on information on the program. You've got to train them on how to help an employee report an incident or file a complaint, and train them on the resources that are available to people who have allegedly experienced harassment. So those other avenues that are available to people that we mentioned previously, the union, for example, the Human Rights Legal Support Center, the Employee Assistance Plan, and so on. Something else that's new to the Act is that the program has to be reviewed as often as necessary, but at least annually. And if there are any what they call substantial changes to the Act, then they have to be provided with notice and some training on that.
In regards to your investigation report, the results of the investigation and the investigation report do not have to be provided to the Occupational Health and Safety Committee. We did touch on this a little earlier and we'll probably go into a little bit more detail now. So for instance, primarily you'd want us to summarise the steps that you've taken, or the investigator has taken, summarise the complaint and the actual response, summarise some of the allegations and some of the evidence, findings of fact, and give a conclusion. Have you confirmed that there is some form of workplace harassment or violence that has taken place within the workplace? provided to the employer or supervisor or a designated person to take action. So recommendations that are very important, and the Ministry of Labor would criticise an investigator for not actually stipulating some form of recommendations or corrective action in regards to what they've identified with the investigation. So you don't have to disclose the names of the person that the allegation's been made against or the witnesses, or detail the specifics of the allegation. It can just be summarised. In summary, you could have an incident where an investigator during a course of the investigation has identified an area which may involve occupational health and safety that needs to be addressed as a result of that investigation. So for instance, an employee who attends a workplace whilst they're on sick leave utilises their key card to access the workplace and then assaults another employee. One of your recommendations there would be that all employees who are on sick leave have restricted access to the workplace. So that may be one form of recommendation. And obviously you would consult the Occupational Health and Safety Committee in regards to that and work closely with them to ensure that your recommendations are implemented.
Yeah, so the provisions of the court that Adam was just going over, those elements, those are things that are detailed as well in the Code of Practice in terms of what the Code of Practice is recommending to meet your obligations. So again, well worth the read to make sure that you are following those essential elements when writing your reports. And I'll talk a little bit more about the Code of Practice in just a couple of minutes. So what do you need to do to be prepared? You need to update your policies, your procedures, your program. And like I said, a lot of employers do put the policy and the program into one document. So if you put a policy that's also a program and sets out all the things required in the program as well, that's, in my mind, going to be sufficient. I think it's actually a better practice to have the program elements in the policy, at least most of them. If there's anything specifically internal just to the investigation procedures, that should be in a separate document. Employees don't need to know about all of that. But there are a lot of things that they are asking to be put into the program that I think would be very valuable and essential for employees to know so that they do understand the process and how everything works. You want to make sure that you are training, what Adam and I talked about that, training those designated individuals on how to conduct a proper investigation to limit the chances that if somebody does challenge an investigation that you're going to be in a position where the ministry finds that it's been flawed. So we want to make sure they're well versed on the law and the policies and all the investigation procedures that are being suggested be followed. You want to make sure your managers, supervisors, those organization leaders are trained on harassment, how to recognize those incidents or complaints of harassment, how to deal with any incidents and complaints that come their way. And one thing that goes a long, long way, at least in terms of not only dealing with complaints of harassment by a supervisor, but also dealing with ongoing issues in a team or department that lead to complaints of harassment, is making sure that your managers are effectively trained as managers in their managerial skills. It's one gap that we often see that leads to a lot of complaints, is we see people promoted into management positions, either internally or from an external candidate, but there's no kind of coaching or training given to the individuals on their leadership trainings. And we often see that as a big gap that leads to a lot of problems, creating these negative and kind of toxic team environments. And that's where we see the harassment complaints coming out of those. So you want to train all your employees on the revised policy and program, and you want to work towards creating that positive, respectful workplace so you can avoid these types of complaints from happening in the first place. That's the ideal situation. So I said I would talk a little bit more about the Code of Practice. It really is something that you want to pay attention to. It does not have the force of law. But they are guidelines, and you can be sure that if the ministry is coming in to scrutinize your conduct in an investigation that you have done, that they are going to be checking your behavior and the steps that you follow against the recommendations they've made in that Code of Practice. So you definitely want to familiarize yourself with that, make sure at a minimum that you're following the procedures that they have suggested. And just to be safe in those situations. It doesn't stop a complaint from being made to the ministry, but it hopefully does mean that it would result in a finding that everything was done properly. So as I said, you can find it on the Ministry of Labor website. If you follow the links towards health and safety, and go to their publications page, you'll find a link to the code of practice on that page.
So the investigation fundamentals, and as an investigator, there's probably 5 key areas that I'll highlight during the next couple of slides. These would include training for designated individuals, and Natasha touched on that. It's really a priority to ensure that they conduct the process of investigation according to the policies. To ensure that they consider the evidence, and also that includes evidence that may exonerate the person from the allegation as well. You must ensure that they don't discard that. They must maintain the confidentiality, and Natasha touched extensively on confidentiality, and objectivity as well. They must be seen to be unbiased. They also must ensure that they are comprehensive and have detailed notes as part of the investigation. So procedural fairness. So we look at the credibility of the investigator, the objectivity, and their sensitivity to the parties. People often feel a little bit more comfortable if the investigator is more open and is also credible in the way that they conduct the investigation. Their processes, the individuals need to be feeling as if they're being heard and they have the opportunity to present their case. The investigator needs to be fair, and that's across the board. And again, I can't highlight the objectivity in regards to that. It also helps to reduce the likelihood of the MOL complaint and that the investigation was not conducted properly. And often if the investigator doesn't follow some of these procedural fairness elements, often the individual who's instigated the initial complaint may actually lodge a further complaint with the MOL, believing that it hasn't been undertaken in an appropriate fashion. Need to follow the internal investigation procedures, and I think I can't highlight that enough, that the investigators conducting the investigation ensures that they follow it in a manner that is consistent with the employer's policies and procedures. They need to be trained. Objectivity, we've touched on that. Fairness, and don't rush to judge. Best evidence is often the freshest, and again, it really highlights it. Acting quickly, we touched on that earlier, often shows to other employees as well that the employer is actually taking the matter quite seriously and that they're not dragging the investigation out. Effective investigators. So a couple of key elements here. We have knowledge, personal attributes, and position and organisational issues. Optics is the key here. The investigator may in reality be unbiased, but may not necessarily appear that way, and that can have an adverse effect on the investigation. Need to ensure that there's no conflict of interest and that the investigator is available and responsive to both the complainant and the witnesses and the person who the allegation is being made against. They need to be knowledgeable in areas of HR law, rules of evidence and assessing credibility of people, and interviewing techniques as well. Their personal attributes, they need to speak comfortably, confident, and develop a rapport with all individuals involved in the investigation. Lead by example, show their professionalism and respect for all those individuals and confidentiality as well. Position and organisational issues, it's ideal for the investigator also making the calls and whether their alleged conduct occurred or if there was a breach of law policy. It's up to them in the conclusions of their report. So selecting an investigator, often that can be, do we select someone who's internal or do we select someone who is external? There's a number of factors that may contribute to actually deciding on whether it is internal or external. The seriousness of the allegation. Does the seriousness of the allegation actually warrant an external investigator coming in? Is there a single incident, or is there a series of incidents that have occurred over an extended period of time that may warrant a further and thorough investigation by a third party? Also, you may look at, is HR too close? Do they know the individuals on a regular basis? Have they been involved in similar sort of complaints or arbitrations previously? So therefore, they need to remove themselves from that investigation to ensure that there's impartiality. Are police involved? And we touched on that earlier. Is this part of a criminal investigation? Does this current investigation need to be held at that particular time until the criminal investigation is complete? Because we don't want to interrupt any further criminal proceedings that may eventuate in the future. Notifying the parties. So we have, you must ensure you notify the complainant and the respondent promptly. And that adds to your credibility as well. Tell the respondent who filed the complaint, the summary of the allegations, representation of the parties and support persons, and they may have a union representative or a lawyer there as well. So you need to ensure that you outline the processes and how it's going to undertake, and that's from A to Z all the way through the investigation to ensure that they have a clear understanding of how you're actually going to conduct the investigation. Provide them with a summary of the allegations. Provide them with not the extent of full details, but obviously they need to be comprehensive so they can be provided the opportunity to respond accordingly.
And that's the respondent, so the witnesses don't get any information, obviously, on the allegations or copy of the complaint. That's just the information that's being provided to the respondent.
Exactly. And support persons as well, they're not there to provide any form of evidence. Then you must ensure that they're not witnesses, and be careful about bringing in someone's manager as a support person who may have a conflict of interest as well. So suggested processes for the interview. So we have obviously the interview complainant, we interview the respondent, and then we interview the witnesses. And that's pretty important that we do it in that order because we want to have a clear understanding straight off what is the actual complaint. And it's important that when you're obtaining a statement from the complainant that you get all available details that you possibly can. Dates, times, what was said, how was it said, the manner in which it was said, their body language and so forth. Then you provide the respondent with the opportunity for them to provide their viewpoint of what occurred. And then you have a real understanding of perhaps what's happened in regards to this incident. Then provides you with information to interview witnesses so that you can ask questions to them specifically relating to facts that either the complainant or the respondent has provided to you in earlier statements. You may need to re-interview other parties if necessary, and of course then make your findings and issue a report. Don't go to witnesses before the respondent unless there are compelling reasons to do so, and I've stipulated earlier as to why. And you must present all allegations, even if it means going back to the person. And that's important. I touched on that a little bit earlier. Even if you do come across certain facts or evidence that may exonerate the person, you need to ensure that they're all included. Natasha touched on confidentiality, and I won't go in depth here. She did a pretty good job on that. So we must maintain confidentiality with the complainant, obviously the respondent, managers and supervisors, and all parties who are involved in the investigation.
I think it's important in that regard to make sure you're setting expectations around confidentiality with the union as well. So in some cases, if the union is not a cooperative party, they can cause some obstacles to you in the investigation. So that should be set out not only in the policy if you have a union, it's a good idea to set out the policy in the program, but it's not a bad idea to see if the union will sign a confidentiality agreement in regard to each investigation as well.
Fair process. Let each side tell their story. I'd be open-minded and not accusatory. Also, interview witnesses who might offer some relevant information. Remain objective, we've touched on that. Review and consider all evidence in a meaningful manner. Detailed notes, very, very important. You must ensure that every time that you do speak to someone in regards to the matter that you record the date and time that you spoke to them, and try, if you can, obtain verbatim as to what they said in their words, because often the way you describe a certain incident may be completely different to how a witness does actually describe it, and that's a key point.
Yeah, the code of practice speaks to that as well, and making sure that you have detailed notes or statements for the investigation. And just one practical point is don't ever throw away your originals. So don't clean, even if you clean them up or type them out, make sure that you keep the originals, because there's always an adverse inference drawn if you don't no longer have your originals in the notes.
Sorry, balance of probabilities, so we can touch on that. So only make findings that you support based on the evidence that you've provided. So make sure that once you've completed your report and your investigation, that you review it thoroughly and ensure that the recommendations or the corrective action is based on the evidence that you provided in that report and not supposition. Remain neutral. We've touched on that objectivity. No personal opinions or views. You don't need to put them into the report. You're purely reporting on the facts that have been presented to you during the course of the investigation. Don't leave any stone unturned. Provide all evidence there that you can, and feel comfortable that what you've provided is everything that you can gather during the course of that investigation.
And just one comment about balance of probability. So that is the standard that you use when you're making your findings. In an investigation, in a workplace investigation, we're not talking about proof beyond a reasonable doubt, which is the criminal standard. And that's why, as well, you saw some differences in what was found in the Gameshi investigation with the workplace investigator who found that harassment did occur. And you saw something different play out in the criminal court. So there are different standards, and those are different charges as well. But balance of probability basically means, what is more likely than not. So it's that 50% plus 1. What do you believe happened factually? And then you make your call on whether, based on those facts, anything happened that would be considered harassment or inappropriate or disrespectful. Just a couple of things in case people want further information about some of these things. Bernardi is running a complimentary webinar on the code of practice specifically that came into effect, and we're doing that on October 28th if anybody wants to contact us and sign up for that. We also run investigation certificate programs, so if you have individuals who need to be trained on how to conduct a workplace investigation internally, we run those programs, and we have one coming up with the Human Resources Professional Association, the HRPA, on November 22nd to 24th. So if you go to the HRPA website or our website, you can get information about that as well. We are also running a program specific to managers and supervisors, a half-day training session, which is going to take place in Mississauga on December 7th. That's available. And then beyond that, if you have any questions or you need some help with your policy or programs to update them and bring them into compliance with these changes, we're obviously more than willing to help you do that as well.
And I'm sure, Natasha, if anybody else has some questions or inquiries about it, they can jump on Bernardi's website or AFIMAC Global.
Yeah, absolutely. If you have specific questions, I'm happy to answer specific questions. If you want to email the firm and let them know you had a question that came out of the webinar today, I'd be happy to shoot you an email back.
Wonderful. Well, I think we've finished under time, which is great, so we can let people continue on, and we appreciate everybody's time. And again, if you have any further questions, please feel free to contact Natasha and myself on appropriate websites.
Thank you.
Thank you.